Hello everyone, Kit here, back with part 2 of this act. And I'm just going to start right where I was before. I'm just going to jump right into it. Section 11, Certificates of Adoption. For each adoption decreed by a court of competent jurisdiction in this state, the court shall require the preparation of a certificate of adoption on a form prescribed and furnished by the state registrar. The certificate of adoption shall include such facts as are necessary to locate and identify the certificate of birth of the person adopted, or in the case of a person who was born in a foreign country, evidence from sources determined to be reliable by the court as to the date and place of birth by such person, shall provide information necessary to establish a new certificate of birth to the person adopted, shall identify the order of adoption, and shall be certified by the clerk of court. Whenever an adoption decree is amended or annulled, the clerk of the court shall prepare a report thereof, which shall include such facts as are necessary to identify the original certificate of adoption and the facts amended in the adoption decree as shall be necessary to properly amend the birth record. Not later than the day of each calendar month or more frequently, as directed by the state registrar, the clerk of the court shall forward to the state registrar certificates of adoption, reports of annulment of adoption, and amendments of decrees of adoption which were entered in the preceding month, together with such related reports as the state registrar shall require. When the state registrar shall receive a certificate of adoption, report of annulment of adoption, or amendment of a decree of adoption for a person born outside of this state, he or she shall forward such certificate or report to the state registrar in the state of birth. If the birth occurred in a foreign country and the child was not a citizen of the United States at the time of birth, the state registrar shall prepare a certificate of foreign birth as provided by Section 12. If the child was born in Canada, the state registrar shall also send a copy of the certificate of adoption, report of annulment of adoption, or amendment of a decree of adoption to the appropriate registration authority in that country. If the child was born in a foreign country but was a citizen of the United States at the time of birth, the state's registrar shall now prepare a certificate of foreign birth and shall notify the adoptive parents of the procedures for obtaining a revised birth certificate for their child through the United States Department of State. Section 12. Certificates of birth following adoption, legitimation, and court determination of paternity and maternity acknowledgement. The state registrar shall establish a new certificate of birth for a person born in this state when he or she receives the following. 1. A certificate of adoption as provided in Section 11, or a certificate of adoption prepared and filled in accordance with the laws of another state or foreign country. A certified copy of the decree of adoption together with information necessary to identify the original certificate of birth and to establish a new certificate of birth, except that a new certificate of birth shall not be established if so requested by the court decreeing the adoption, the adopted parents, or the adopted person. 2. A request that a new certificate will be established as prescribed by regulation, and such evidence as required by regulation proving that such persons had been legitimated, or that court of competent jurisdiction has determined the paternity of such person, or that both parents have acknowledged the paternity of such person, and request the surname be changed from that shown on the original certificate. When a new certificate of birth is established, the actual city and or country and date of birth shall be shown. The new certificate shall be substituted for the original certificate of birth in the files, and the original certificate of birth and the evidence of adoption, legitimation, court determination, and of paternity and paternity acknowledgement shall not be subject to inspection except upon order of a court of competent jurisdiction, or as provided by regulation, or as otherwise provided by state law. Upon receipt of report of an amended decree of adoption, The certificate of birth shall be amended as provided by regulation. Upon receipt of a report or decree of annulment of adoption, the original certificate of birth shall be restored to its place in the files, and the new certificate and evidence shall not be subject to inspection, except upon order of a court of competent jurisdiction or as provided by regulation. Upon written request of both parents and receipt of a sworn acknowledgement of paternity signed by both parents of a child born out of wedlock, the state registrar shall reflect such paternity on the certificate of birth in the manner prescribed by regulation if paternity is not already shown on the certificate of birth. If no certificate of birth is on file for the person for whom a new birth certificate is to be established under this section, and the date and place of birth have not been determined in the adoption or paternity proceedings, a delayed certificate of birth shall be filed with the state registrar as provided in Section 9 or Section 10 of this Act. When the state registrar receives information that a certificate may be registered through fraud or misrepresentation, he or she shall withhold insurance of any copy of that certificate pending an administrative hearing to determine whether fraud or misrepresentation has occurred. The state registrar shall offer the restraint or the restraint's authorized representatives notice and opportunity to be heard. If upon conclusion of the hearing no fraud or misrepresentation is found, copies may be issued. If upon conclusion of the hearing fraud or misrepresentation is found, the state registrar shall remove the certificate from the file. The certificate and evidence shall be retained, but shall not be subject to inspection or copying except under order of a court of competent jurisdiction, or by a state registrar for purposes administrating the Vital Statistics Program. No person shall prepare or issue any certificate which purports to be an original certified copy or copy of a vital record, except as authorized in this Act or regulations adopted hereunder. Section 25 Fees. The state agency shall prescribe by regulation the fee to be paid for the following services: certified copies or of certificates or records, or for search of the files or records when no copy is made, or for copies or information provided for research, statistical, or administrative purposes. The replacement of a birth certificate subsequent to adoption, legitimation, paternity information or acknowledgement, or court order. The filing of a delayed registration of a vital event. The amendment of a vital record, provided that no fee shall be charged for amendment completed within 1 year after the filling of the record, and other services as determined by regulation. In addition to the fee prescribed by regulation for a certified copy of the certificate or record, the state registrar shall collect an additional fee of blank money sign for each copy requested to be deposited in the State Vital Statistics Improvement Fund. Funds collected pursuant to this section shall be used to modernize and automate the system of vital statistics in the state. Such funds shall not be used to supplant existing funding which is necessary for the daily operation of the system of vital statistics. Fees collected under this section by the state registrar shall be deposited in the general fund, special vital statistics fund of the state, according to the procedures established by the laws governing collection, the state treasurer, fees for special programs, research, and the state vital statistics improvement fund shall be retained in a non-lapsing fund for the improvement of the system of vital statistics. Section 26. Persons required to keep records. Every person in charge of an institution shall keep a record of personal data concerning each person admitted or confined to such institution. This record shall include such information as required for the certificates of birth and death, and the reports of fatal death and induced termination of pregnancy required by this Act. The record shall be made at the time of admission from information provided by the person being admitted or confined, but when it cannot be so obtained, the information shall be obtained from the relatives or other persons acquainted with the facts. The name and address of the person provided in the information shall be a part of the record. When a dead body or fetus is released or disposed of by an institution, the person in charge of the institution shall keep a record showing the name of the deceased, date of death, name and address of the person to whom the body or fetus is released, and the date of the removal from the institution. If found disposition is to be made by the institution, the date, place, and manner of disposition shall also be recorded. A funeral director, embalmer, sexton, or other person who removes from the place of death, transports, or makes found disposition of a dead body or fetus, in addition to filling any certificate or other report required by this act or regulations promulgated hereunder, shall keep a record which shall identify the body and such information pertaining to his or her receipt, removal, delivery, burial, or cremation of such body, as may be required by regulations adopted by the state agency. Records maintained under this section shall be retained for a period of not less than blank years and shall be made available for inspection by the state registrar or his or her representative upon demand. Section 27. Duties to furnish information. Any person having knowledge of the fact shall furnish such information as he or she may possess regarding any birth, death, fatal death, induced termination of pregnancy, marriage or divorce, dissolution of marriage, or annulment upon demand of the state registrar. Any person or institution that in good faith provides information required by this act or regulation shall not be subject to any action for damages. Not later than the 10th day of the month of occurrence, the administrator of each institution shall send to the Office of Vital Statistics a list showing all births and deaths occurring in that institution during the preceding month. Such list shall be on forms provided by the state registrar. Not later than the 10th day of the month following the month of occurrence, each funeral director shall send to the Office of Vital Statistics a list showing all dead bodies embalmed or otherwise prepared for the final disposition, or dead bodies found disposed of by the funeral director during the preceding month. Such list shall it be made on forms provided by the state registrar. Section 28. Matching of birth and death certificates. To protect the integrity of vital records and to prevent the fraudulent use of birth certificates of deceased persons, the state registrar is hereby authorized to match birth and death certificates in accordance with regulations which require proof beyond a reasonable doubt the fact of death, and depose the facts of death to the appropriate birth certificate. Copies issued from birth certificates marked deceased and shall be similarly marked. Section 29. Penalties. A fine of not more than $10,000 or imprisonment of not more than 5 years or both shall be imposed on any person who willfully and knowingly makes false statement in a certificate, record, or report required by this act, or an application of an amendment thereof, or in an application of a certified copy of a vital record, or who willfully and knowingly supplies false information intending that such information will be used in the preparation of any such report, record, or certificate, or amendment thereof, or any person who, without lawful authority, with the intent to deceive, makes counterfeits, alters, amends, or multiplies any certificate, record, or report required by this act, or a certified copy of such certificate, record, or report, or any person who willfully and knowingly obtains, possesses, uses, sells, furnishes, or attempts to obtain, possesses, or use, or sell, or furnish, or to furnish to another, for any purpose of deception, any certificate, record, or report required by this act, or certified copy thereof to be made, so made counterfeited, altered, amended, or mutilated, or which is false in whole or in part, or which relates to the birth of another person, or the living or deceased, or any employee of the Office of Vital Statistics, or any office designated by under Section 5, who willfully and knowingly furnishes or processes a certificate of birth or certified copy of a certificate of birth with the knowledge or intention that to be used for the purposes of deception, or any person who without lawful authority possesses any certificate, record, or report required by this act, or a copy or certified copy of such certificate, record, or report, knowing same to have been stolen or otherwise unlawfully obtained. A fine of not more than $1,000 or imprisonment of not more than 1 year or both shall be imposed on any person who willfully and knowingly refuses to provide information required by this act or regulations adopted hereunder, or any person who willfully and knowingly transports and or accepts for transportation internment, or other disposition a dead body without accompanying permit as provided in this act, or any person who willfully and knowingly neglects or violates any of the provisions of this act, or refuses to perform any of the duties imposed upon him or her by this act. And yeah, that's what this, as far as I'm going to read about this for this one, guys. I'll leave a link to this down in the description box below, along with our email. You can email us at themonzygmail.com for private consultation, and I'll see you guys next video. Have a nice day. Goodbye.